Can we seek a driver's consent to conduct a pat-down on them if we take them out of the car? My name is Anthony Bandiero, attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing it a Roadside Chat. All right, so this question comes from an officer in Idaho, and the question, or the background here is, on a routine basis, when I request someone to exit a vehicle, either for field sobriety tests, I have PC to search the car, or some other reasoning, right? I ask them for consent to perform a pat-down and search of their person. If they do not provide consent, I inform them that I am performing a pat-down for weapons and articulate why I believe them to be armed and dangerous. Is this acceptable under the Fourth Amendment? Or have I been violating people's rights? I've also been careful about the language and the wording that I use. I usually say something like, do you mind if I pat you down and search you? Or similar verbiage. All right, so let's go through this. Number one, the getting people out of cars, right, is generally permissible without any particularized need. You don't need reasonable suspicion or probable cause normally. That's Pennsylvania versus Mims for the driver. That is Maryland versus Wilson for the passengers. Okay, we get them out. Can we seek consent to do the pat-down? The answer is yes, right? Absolutely, we can seek consent. We can, the way that the officer is asking, though, do you mind? I don't suggest that you say, do you mind? Because if they say yes or no, it can be interpreted either way. Do you mind if I pat you down? Yes. Yes, you mind, or yes, you can pat me down. Do you mind if I can pat you down? No. No, you don't mind, or no, I can't pat you down. So say things like, sir, ma'am, may I pat you down for officer safety? May I search you for officer safety? Those type of things would be much better. Then if they say no, and you still have reasons to believe they are armed and dangerous, then you can still pat them down. But I would be cautious and be prepared for one counter argument that goes like this. Officer, before you patted my client down, did you have reasons to believe they were armed and dangerous? And the officer says yes. But then you asked them for permission to pat them down. Yes. So why are you asking a person to be safe, right? Why, if you thought your safety was in jeopardy, why are you asking them for their permission for you to be safe? In other words, what the defense attorneys may do is attack the credibility of the officer, basically by saying, look, you really didn't have armed and dangerous, right? You were just looking, hopefully they would say yes, and you wouldn't have to articulate it. But because they said no, now you're scrambling for facts to justify your behavior. That's going to be the argument, right? And it's a good one. I mean, it's not a frivolous argument. Maybe cops that really do believe that somebody's armed and dangerous should just do that pat down and be safe and not ask permission for them to remove weapons from them and so forth. However, at the same time, there is value in asking for consent. It gives you another reason to search. It adds another layer of protection. Maybe if the court did believe that your reasons for pat down were thin, right? This gives you another element of protection for the conduct, but just something to consider. All right, so there's your answer. You can do it, but just keep in mind that counter argument. Keep the questions coming. Please like, subscribe, comment, share with your friends. All those things help grow the channel. Let's help cops make good case law. All right. Until next time, my friends, stay safe.